Good evening and welcome to the November 21st, 2022 meeting of the Lake Oswego Development Review Commission. Kat, would you please call the roll of commissioners present?
Arthur?
Here.
Smith?
Here.
Shear?
Here.
Poinsett?
Here.
Dews?
Here.
And we have Timothy Lyons and Dwight Sangre as excused this evening.
Great. We have a quorum. I appreciate Vice Chair Kirk Smith's presence and the other commissioners who are with us. Our first item of business is review and approval of the minutes of the October 17th, 2022 meeting of the Development Review Commission. These were circulated in advance. A draft was circulated in advance for commissioners' review. Commissioners, are there any suggested modifications to the draft minutes? If not, is there a motion?
Move to approve.
Second. Commissioner Smith moved to approve. Commissioner Shearer seconded. All in favor, please say aye. Aye. Any opposed? Any abstentions? Very good. The draft minutes are approved as submitted. Our next agenda item relates to a public hearing for AP 22-06, a request for a hearing to appeal the tentative staff decision to approve a Type 2 tree application to remove 146-inch DBH Douglas fir in order to construct a garage addition to an existing single-family dwelling. And this site is located at 817 D Avenue in Lake Oswego. Our staff coordinator is Daphne Sissel, Associate Planner, and I would invite Attorney Boone to open up the meeting.
Thank you, Mr. Chair. And before I start, just to the commission and the audience, I'll be wearing a hat through the meeting due to a skin treatment thing that's going on in my head. But the hat's better than the head. So this is a public hearing. With the process is as follows. There'll be a presentation by staff and testimony by the applicant up to 20 minutes. Then testimony by parties in support of the application, followed by testimony by parties opposed to the application, and finally testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes. Any person in attendance may cede his or her time for testimony to another person except to the applicant, but in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Time limits do not include time spent responding to questions from the commission. Testimonies by attorneys, representatives, and witnesses on behalf of which are part of the presentation by a person shall be counted within that person's time limit. It is assumed the persons are testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they are representing. After testimony in favor, opposed, neither for nor against, in the applicant's rebuttal will occur up to 5 minutes. Then commission deliberation, including a statement to the applicant by the commission of any proposed conditions of approval different than contained in the staff report, and the applicant's response to the commission's conditions of approval proposed following commission deliberation. As stated in the public notice, the deadline for submission of written materials was noon today. No written materials may be submitted to the commission tonight. This tree removal request is to be considered based upon the applicable criteria and standards. The staff report lists the criteria and that staff identified as applicable to the request. It was available online and from the planning department. Testimony and evidence must be directed towards the applicable criteria. We ask that you specifically identify to the commission the criteria or standards you're addressing, so the commission may consider your testimony in relation to that criteria or standards. If you do not identify the criteria or standards you're addressing, the commission is not obliged to guess which standards or criteria you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission and the parties an opportunity to respond to the issue precludes raising the issue to the City Council and on appeal. The failure of the applicant to raise any constitutional or other issues relating to proposed conditions of approval with specificity to allow the commission to respond to the issue precludes an action for damages in circuit court. Now, potential conflict of interest declared on behalf of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known present or anticipated future business relationship with the project or the applicant. It's possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244-020. At this point, I would ask the commission members to please declare if you've had any ex parte contacts, including a site visit, if you have any bias on the application, If you're any financial conflicts of interest to declare, and please state your business or employment. Commissioner Dews.
Good evening. I am John Dews. I am an architect with Target Corporation. I did drive by the site over the weekend. I've had no ex parte contacts. I have no bias in regards to this project, nor do I have any financial conflict of interest.
Thank you. Commissioner Poinsett?
My name is Bruce Poinsett. I'm a construction safety consultant, partner in firm GW LLC. I've had no contact with anyone to deal with the project, no ex parte contact. I did drive by the site, no biases whatsoever.
Thank you, Commissioner Shearer.
My name's Jeff Shearer. I'm a retired contractor. I have no bias. I have no financial conflicts. I did not do a site visit. I think that's it. Thanks.
Thank you. I'm Randy Arthur. I'm a civil litigation attorney with the Portland office of the Bullivant Hauser Bailey Law Firm. I did not make a site visit. I've had no ex parte contacts. I have no financial interest in the application, and I have no disqualifying bias. Prior to tonight's meeting, I was furnished a list of potential actors relating to the application, and we did run it through our conflict system and did not have any potential or real conflicts of interest. Thank you. Vice Chair Smith.
My name is Kirk Smith. I'm a real estate land use attorney with the law firm of Buck Culture. I've had no ex parte contacts. I did not make a site visit. I have no disqualifying bias and no financial conflicts of interest.
Thank you. Is there any challenge to Commissioner's right to consider the application? Hearing none, staff report. Go ahead.
Good evening, Commissioners. My name is Daphne Sissel, Associate Planner for the City and Staff Coordinator for this tree removal application. Before I begin my presentation, I would like to introduce Exhibit F004, which is supplemental information submitted on behalf of the applicant, and Exhibits G221 through G224. Exhibits G221 through G223 were received in opposition to the tree removal and reiterated previous concerns that have been addressed in the staff report. Exhibit G224 are photos that include reference to alternative driveway materials, but no other context was given. The Type 2 tree removal application 499-22-001206-tree is for address 817 D Avenue, which is within the R6 zone, a residential medium density zone. All Type 2 applications must meet the Type 2 criteria for issuance to be approved for removal. Criterion 1 is the reason for removal. The tree is requested for removal to construct an addition to an existing single-car garage and expand the driveway. The 46-inch Douglas fir is located within the footprint of the proposed addition. The removal is for development. This criterion is met. Criteria 2 addresses impacts on erosion control, flow of surface water, and protection of adjacent trees. Based on the evidence provided in the application and the city's contract arborist assessment, the requested tree removal will not result in significant negative impacts on erosion control, flow of surface waters, or protection of adjacent trees or existing windbreaks. This criterion is met. Criteria 3 addresses tree removal impacts on the character or aesthetics of the neighborhood. This standard is met if the removal of the trees does not involve a significant tree, alterations to distinctive features or continuity of the neighborhood skyline, trees serving as a visual screen between different neighborhood zoning, a street tree, or removal of 50% or more of a stand of trees. I will be focusing on the elements that are relevant to this application, specifically the significance of the tree and the alterations to distinctive features or continuity of the neighborhood skyline. Significance is defined as a healthy, non-invasive tree over 15 inches in diameter that is considered significant to the neighborhood due to size, species, or distinctive character, or the only remaining tree on the property. The tree was listed by the applicant's arborist as fair condition, which the city has used as an indication of healthy. The tree exceeds 15 inches in diameter and is a Douglas fir tree, which is a non-invasive native species. Since the 46-inch tree meets the first three elements, it will be looked at for significance due to size, species, or distinct characteristic. Staff found the tree to be among one of the largest in the neighborhood. It is a Doug fir, which is not rare or unusual for this neighborhood, and staff found the tree does not provide distinctive character to the neighborhood. The 46-inch Doug fir is found to be significant to the neighborhood due to its size. The tree is also not the only remaining tree on the property, as there are other smaller trees on the property that will be retained. Even if trees are not considered significant due to size, species, or distinctive character, the applicant must show that the removal will not have a significant negative impact to the distinctive features or continuity of the skyline. Just looking at the photo included on this slide, which is a view of the tree from D Avenue, staff finds that the requested removal would have a significant negative impact on the character or aesthetics of the neighborhood due to the loss of continuity of the neighborhood skyline. Because the tree removal will have a significant negative impact on the character or aesthetics of the neighborhood due to loss of continuity of the neighborhood skyline, reasonable alternatives to tree removal must be considered by the applicant. This photo here shows the existing single-car garage at 817 D Avenue with the 46-inch Doug fir on the left. The green box on this site plan shows the current footprint of the home, which was built in 1947, with the proposed additional footprints indicated by the hatched areas. As you can see, the tree, marked with the red X, is within the proposed footprint of the addition to the garage. All new construction must meet current zoning standards, including setbacks. This is referred to as the available building envelope, shown here in blue, the blue rectangle. As you can see, a portion of the structure is non-conforming on the north side, where it does not meet the required 7.5-foot side yard setback. Additions to non-conforming structures cannot increase the degree of nonconformity, so all new construction must fully conform to the current code standards. Setbacks for R6 are 7.5 feet for side yard setbacks, so that's to the north and south on this property, 15 feet for the rear, which is to the west, and 20 feet from the front, which is along 8th Street to the east. The proposed plans under review for the additions to 817 D Avenue have been shown to meet all code standards and are within the available building envelope, as you can see. The applicant was asked to provide an alternative analysis, which they did. This alternative shows the critical root zone for the tree, indicated by the green dashed line, and a 2-car garage with alley access, shown in pink. It's a little hard to see, but there we go. So this is the addition for an alternative here. This red line shows the alternative meeting the rear yard setback at 15 feet. This alternative design would have impacts to the root system on the north side and require 2-foot deep grading and excavation for the addition, as well as work occurring within 1 foot of the trunk. This was shown not to be a reasonable alternative, as the impacts to the tree are too great, as well as not providing adequate growing space for the future. Several public comments suggested that the garage be built on the east side of the structure to retain the tree. Community Development Code Section 50.06.001-4B, Garage Appearance and Location Standards for the R6 zone, only allows for garages to be alley access or to be located between the alley and the primary structure if the property is located on a corner lot, as this property is, which allows for street access, which it currently has. Subsequently, the applicant was not required to submit alternative analysis for the east side of the property, as a garage would not be allowed here by code. The next few slides are going to be alternative site plans that were suggested in the public comments. This slide shows an alternative proposed location suggested by public comments for an attached single-car garage for tandem parking, 1 car behind another. The light blue box is the existing parking for a single-car garage. The darker blue box indicates where the garage addition would be located in this scenario, using the dimensions of a 12 by 22 single-car garage footprint that was suggested in a public comment as a standard size for a single-car garage. This alternative is not feasible because it not only violates the garage appearance and location standards for R6 that require the garage to be set back 2 feet from the primary structure, It also would not meet the side yard setbacks, as well as crossing the property line slightly. So down here at the, there we go. So even using that 12 by 22, it crosses the property line. Another suggestion from a public comment used that, another suggestion was for a detached single-car garage located over the existing concrete pad. This alternative, again, does not meet setbacks, and the tree is still located within the proposed footprint. Another suggestion from a public comment used the applicant's analysis drawing to show a single-car garage with alley access. The highlighted yellow areas are the existing driveway there to the south and the alternate location for a new garage, which is surrounded by a red box. The blue box indicates the current parking inside the existing garage. This alternative, again, does not meet rear yard setbacks indicated by the red line that's north and south there. And if moved to accommodate the rear yard setback, the garage would displace the current parking, resulting in required alterations that would violate the garage appearance and location standards that were mentioned earlier with the tandem parking suggestion. Staff finds that the applicant has shown that there are no reasonable alternatives that meet current zoning standards and the approval criteria of LOC 55.02.080 have been met, specifically the exception to criterion 3, because there are no reasonable alternatives. Staff recommends approval with the following conditions of approval. Prior to issuance of the building permit, submit a mitigation plan showing the location, size, and species of 2 native mitigation trees. And prior to the final inspection for the dwelling, plant the required mitigation trees per condition A and request an inspection by staff. Thank you. That concludes my presentation, but if there are any questions, I'm happy to answer them.
Thank you. I appreciated your detailed written report and good presentation. Commissioners, are there questions of staff before we receive testimony? Hearing none, we will proceed to testimony and invite the applicant to come forward. Good evening. Please identify yourself and proceed.
For the record, Jamie Housley with law firm here on behalf of the property owners. And the property owners are away on a previously scheduled trip, given that this is the week of Thanksgiving. With me this evening are Kurt Olson, our architect, as well as Trevor March, one arborist, and Todd Prager, another arborist. We want to thank Daphne for her thorough staff report and her presentation this evening, and believe that the city staff here is correct in their thinking and that you should follow through on their recommendation and deny the appeal. We did submit a letter to you earlier this morning, and it contained an additional exhibit, which was a memorandum from Mr. Prager confirming the analysis conducted by Mr. March, as well as the city's contract arborist. I'm going to go here and describe a few thoughts here from the owner's perspective, and then leave time for us to answer any questions you may have, and I'll make available the applicant team if you have any specific things for the architects or the arborists. But this house is 1,212 square feet. It's only 2-bedroom. It was built in 1947. The fir trees root protection zone consumes 24% of the entire lot. And that was indicated in the letter we provided you today. And as Ms. Cicel explained, a westward expansion towards the tree is really the only thing available to us due to other code constraints. And it's really the only feasible design in terms of the ability to modernize the house and garage here. And again, we are allowed to do that by code to build within that building footprint. The opponents have not provided any expert testimony that the tree can survive a westward expansion addition to the house, even if the driveway were moved to D Avenue to the alley. Furthermore, the opponents failed to acknowledge that the proposed addition is allowed by code because it's a permitted use of the lot, which conforms to all of the clear and objective criteria and development standards in Lake Oswego City Code, such as the setbacks and the height. As we explained to the DRC here back in June, the city can only apply clear and objective criteria to standards and applications involving housing. And again, our letter goes into great detail on those points. I don't want to belabor that again, since you recently heard that from me. So with that, again, we ask that you deny the appeal and potentially work with the city council in the future to revise those portions of the city code to conform with Oregon law in terms of the clear and objective criteria, and that effectively support the staff decision, deny the appeal, and we would agree with the conditions of approval set forth this evening. So with that, I will pause and see if there's any questions.
Are there questions from commissioners?
Thank you.
I think we have none. Thank you. I next wanted to call upon witnesses who may be speaking in favor of the applicant. I have no names of anyone either in person or by Zoom wishing to speak. Is that correct? And that,
I would just say our witnesses are available to answer questions, but I don't see the need to bring them up here on this holiday week. I know everybody wants to get out of here. Thank you.
and my comment was directed to members of the public who might be testifying in favor. I do have the names of some citizens who wish to testify in opposition, so I will call those names. Diana Schmidt, would you please come forward? Good evening.
Good evening. My name is Diana Schmidt. I'm here this evening to appeal to both the applicants, their representatives, and the decision makers to preserve the very large, significant, and healthy 46-inch Doug fir tree at 817 D Avenue. The purpose of the tree code is to preserve the wooded character of the city of Lake Oswego and to protect trees as a natural resource of the city. The mature tree canopy of Lake Oswego has been established to be one of its most precious assets, and one of the greatest charms of the First Edition neighborhood is the presence of large and mature trees, including many who have now been recognized with heritage status. The very existence of these large trees and the desirability of the First Edition neighborhood points to the fact that as a community, we recognize and highly value their importance and the contribution they make to all of our daily lives. And it is through continued and thoughtful consideration of that contribution that only mature trees can make, that we are working together to ensure that they remain. It is what has attracted most of us to live here, and we consider the individual trees on our streets and avenues to be vital, cherished members of the community, no less so than our human neighbors. In fact, it's crucial to remind ourselves when considering whether to cut down these old trees that we will come and go, but given the chance, these trees will long outlive us, taking nothing and giving everything in return to the generations that preceded us and those that will follow. The 150-year-old 46-inch tree at 817 D Avenue is a grand and prominent feature in its surroundings, an asset not only to the property owners, but to the neighborhood at large. D Avenue is an important walking and driving corridor, and this tree is highly visible. It is seen, appreciated, and admired by all passers-by. Due to the size of the tree, its removal would have an indisputably negative and glaring impact on the character and aesthetics of the neighborhood. While this Douglas fir is not an unusual or rare species, This particular individual is certainly significant to the neighborhood due to its size. Due to both its size and location, cutting it down would alter a distinctive feature of D Avenue and permanently alter continuity of the neighborhood skyline. Large old trees are not simply enlarged versions of young trees. A healthy community of trees requires that we preserve and maintain trees at all stages, including a tree exactly like this one, a healthy tree with substantial structural significance that has managed to thrive for over 150 years in its current location. We must realize that it is not truly possible to mitigate the loss of this large, old, and healthy tree. Planting 1 or 2 young trees elsewhere on the property could not begin to replace what would be lost. We would be making a grave error in judgment if we felt justified in sacrificing this important and irreplaceable individual, even if the proposed development is technically permitted. There are always other reasonable solutions available if we accept and give weight to our role, obligations, and responsibilities as caretakers and guardians. With respect, I urge the applicants to consider all other options, those they may not have even thought of yet. Although something may be permitted, it is not always the right choice. We must recognize and acknowledge the cumulative damaging effect of cutting down one old tree at a time. We are at a critical juncture. Rather than cutting down one more very large and very important tree, we must take a step back and consider the whole and acknowledge the far-reaching impact that such actions have on us all. I submit my support for the appeal and request denial of the application until the project can be redesigned to keep this significant tree. Thank you for your time.
Thank you, Ms. Schmidt. Commissioners, do you have any questions of Ms. Schmidt? And Ms. Schmidt, you were testifying on your own behalf, is that correct?
Yes, sir.
I did have a question. So I believe your testimony really highlighted and emphasized the significance of this tree. You mentioned, I think, that there should be other alternatives permitted within the zone that should be explored. Did you have a specific reasonable alternative that you feel has not been considered?
I'm afraid I don't. I only recently became aware of this, and I know that engineering can get very creative, and I know sometimes that can increase costs and is not always the first option. But I do think when it's a tree as significant as this is in this location, that perhaps more time could be given and there might still be another option out there.
Well, thank you very much. We very much appreciate you being here tonight and your thoughtful testimony.
You're welcome. And I also, this is my first, I was curious, it seemed that 2 of the 5 decision makers here tonight visited the site, but 3 of you have not. Is that normal?
Yes, we simply declare if we've made a site visit.
And is it not important when it's a tree such as this to see it in person and on site to really understand its significance?
Well, I think there are pros and cons. We listen to the evidence and testimony that's presented. And if we do make a site visit, it's my understanding we need to give a detailed statement of what we saw so that everyone else is apprised of our observations and how it relates to the application. You raise a good point, but it's my practice typically not to make a site visit.
All right, thank you.
Thank you very much. Our next witness in opposition is Jill Cabral, and I apologize if I mispronounced your name. Please come forward. Are you testifying as an individual witness?
I'm testifying for the Neighborhood Association.
I see. So that means you have 10 minutes. Is that
I
correct?
do, I
City Attorney?
should, yes,
Very good.
per the rules.
Please identify your name for the record.
My name is Jill Cabral Shin, and I'm here tonight to represent the First Edition and Forest Hills Neighborhood Association.
Good evening.
Thanks. Good to see you all. I'm here to represent the First Edition Forest Hills Neighborhood Association and our request to overturn the approval of permit. Oh, can I have my presentation up also? That'd be awesome. Thank you. Great, thanks. Thank you all in advance for your time and consideration of my presentation, and for all those who showed up here tonight. Tonight, I will cover the significance of this tree, its importance to the neighborhood, misleading statements or missing information from application and staff findings, the current state of the property, and potential solutions to save the tree. I think we can all agree at this point that this is clearly a healthy, significant tree. It is 46 inches in diameter. It is well over 100 feet tall. And in their report, the staff agreed with this, that the tree was significant, so much so that they added an additional mitigation tree, a Douglas fir, to be planted pending approval, which I immensely appreciate. If you have just read the application and the comments, I would say that words do not convey the full picture of how significant this tree is to the neighborhood and that specific location. There are a few pictures here on the slide that I've provided, but I don't think those do it justice either. It is certainly one of the tallest trees in the area and can be seen from all across the neighborhood. It is a major part of that specific section of the neighborhood. It is on the corner of one of the neighborhood's most traveled roads, a major and prominent thoroughfare, and the only road east to west with a sidewalk. So any neighbors that are walking around the neighborhood are walking by this tree, and as you can see from these pictures, it's very, very close to the sidewalk. One neighbor said of the tree, "I walk past this magnificent Douglas fir several times a week, sometimes several times a day. It is a standalone sentinel to passersby. It is the most beautiful and significant tree, a wonderful asset to our neighborhood." Another neighbor shared, "If this one goes, it will be number 5 within a block in the same alley. I've looked at this tree from my window for almost 70 years. It would be a great loss to have it removed, especially since the other trees have already been cut down. I don't understand why such a grand tree couldn't be accommodated with a different design. It's a shame it survived over 100 years being part of our neighborhood. Once again, it would be a great loss to have it removed." Again, I think we can all agree this tree is extremely important to the neighborhood, and the applicant, the architect, and the city should all be working together to find a feasible solution to preserve this significant tree. That is what the code was written for. Despite having half of its root system covered by cement and pavement, this tree has continued to thrive. That was one thing that really stood out to me in this application. Instead of being stewarded and properly taken care of, this majestic tree has been painted as a nuisance. The applicant states that the tree has already outgrown the landscape area and is causing damage to the existing concrete. As you can see, a small wall and concrete pad were clearly built right up to the tree, not allowing for any growth. If the landscape area intentionally does not allow for growth, the applicant has created this situation, and the tree should not be blamed. There is no current damage to the driveway, as you can see from the picture. The lifted cement panel was clearly designed that way, unless this tree has become a highly skilled mason in its spare time, because those are very clear, precise, intentional cuts. The applicant states that it is not the only tree on the property, but it is the only large tree on the property. As you can see in the picture, there is one large shrub-like tree in the front of the house, and a spindly birch or aspen maybe to the side of the house. It was hard to tell without going onto the property. There's also a street tree adjacent to the property, which I believe is a young maple. The bird's eye view of the property provided with the application is outdated and misleading. It is important to emphasize that there will be just 2 small to medium-sized trees and an assortment of shrubs remaining on this property if this significant Doug fir is taken down. Also, the applicant states that it is not more than 50% of the stand, which I would agree with. It is not. However, this tree used to be part of a stand, and that stand is being dismantled 1 tree at a time due to lot lines. I urge you to take that into account in considering the weight of cutting down this significant tree. Again, the code was made to protect our trees, especially those everyone involved agrees is significant, and to encourage creative thinking to find alternative solutions to retain our significant community assets while balancing the interests of property owners and surrounding neighbors. Last Monday at the City Council meeting, Councilor Raff highlighted the divisiveness of this process and urged people across the board to work together to find solutions. So that is what I am trying to do here. I also apologize for the typo on this slide. It should say 24 inches, not 24 feet. It is clear the applicant has tried a couple of different solutions of alternative plans. However, I did not hear the obvious use of the already existing concrete pad in the front listed as an option. It seems like you could construct some walls and a roof in there and solve the problem fairly easily. I did hear Daphne describe that was up against some of the setbacks, but setbacks certainly get variances all the time, so I think that's something that should be considered. I'm not completely sure why they need to dig down 18 to 24 inches when coming in off the alley, or why this needs to be all hardscape. Can they simply level the ground and then put a permeable surface for the driveway portion, add a concrete slab and build up, and possibly add a few stairs down to the back of the other garage? I did not see this option mentioned. It also stated that building off the alley was not feasible because it would then create too much hard surface all around the tree. Could they build off the alley and then remove the other concrete pad out front and simply swap the impermeable surface, allowing the tree to breathe, receive water, and ultimately remain? Can the second garage not go on the other side of the house? Again, I just heard Daphne describe that it could not because of some other regulations. Is there a variance to that? Is there a way around those regulations? I don't see that considered either. I'm also confused by the denial of their proposed alternative entrance on D. What or where was that entrance going to be? There's already an entrance on D, so are they just trying to expand that? And why wouldn't the city approve it? Was it completely unfeasible? Could there have been some tweaks to make it work? Further information and contact should be provided so we could use this information to hopefully find a feasible solution together. It also looks like they're bringing out a portion of the house further. Is it possible to bring out the garage entrance further so that two cars could be stacked? Is a way to build that stacked garage that it doesn't go over the lot line, as Daphne described earlier. This would again have minimal change in the situation the tree currently endures. As you can see, this lot has plenty of room for creative solutions for a second garage. I implore you to overturn the approval of this permit and send it back to the staff to talk to the applicant, architect, and the city to collaborate together, maybe allow a variance to come up with a solution to this project that would retain this significant tree. There must be something they can agree on. I'm also slightly concerned about the location of the mitigation tree proposed. It looks extremely close to an existing paver patio. I certainly wouldn't want to cut it down in the near future for it to be outgrowing its landscaping space already. On the left here, you will see the diagram provided by the architect. In the middle, the standard dimensions of a garage, and on the right, an alternative proposed by Suzanne Meckel in her written comments. Again, Daphne went over this one before, and I can certainly talk through it, but my question is, can we just talk to the city about allowing that variance? And if you can see that one on the right there, the yellow, if you just turn it the other way, you can park one car one direction, one car the other direction. There's lots of room for the tree with a simple variance, which again, they happen all the time. In both of these scenarios, they would also still retain that additional concrete pad out front so that it actually have parking for 3 cars. Again, the easiest scenario is just to simply use the concrete pad, get a variance, and build a roof and walls and use that concrete pad for that garage. Given they did not mention a garage with an entrance on 8th, or building the already existing concrete pad, or removing that pad to build a garage on the other side, I can confidently say that all reasonable alternatives have not been explored. There's also no explanation as to why a second garage is needed, in addition to the garage and concrete pad that are already on the property. The need for a second garage certainly bears further explanation if they're going to cut down a majestic 46-inch tree, the only large tree on the property that has been providing community benefit for well over 150 years. Again, the code was put in place to set up protection for our significant trees. If we can all agree this tree is significant, can we all agree that we should work to uphold the code and find collaborative solutions rather than to work so hard to justify why it is okay that we continue to cut these significant trees down? Here again is everyone's favorite slide. Since 2016, there have been now 233 just type 2 trees just in first edition alone, plus one more with this application that makes 234, with only 8 saved. I implore you to overturn the approval of this permit and send it back to the applicant, staff, and the city to collaborate and determine a feasible solution to retain this magnificent tree, our important community asset, over a second garage. There must be a solution to preserve this tree and meet homeowners' needs. I believe we can work together to find it. we must before it is too late.
Thank you for your comments on behalf of the Neighborhood Association. Commissioners, are there any questions? I just wanted to confirm, and I'm sorry, I don't have the complete spelling of your name here.
It's okay.
But the Neighborhood Association has not submitted an arborist report or analysis of reasonable alternatives to save the tree, is that correct?
We did not, as we weren't able to get on the property to do a arborist report.
Or
We had done one from beside the property last time, and that didn't seem like that was a good solution to everyone, so I did not pay for that this time.
Or other building professional testimony about reasonable alternatives permitted in the zone to save the tree?
We did not.
Well, I very much appreciate your detailed testimony and the diligence and conscientiousness of the Neighborhood Association in looking at the development proposals. So thank you for being here tonight. Our next, the next witness I have, whose name I have, Suzanne Meckel. Please come forward. Good evening.
Good evening. Thank you for being here and appreciate you.
Well, we appreciate your taking the time to comment.
Testimony. Thank you.
Are you testifying on your own behalf as an individual?
I am, yes, thank you. And I do have some photos that I submitted as well.
Can you move the microphone closer to your
I'll
mouth?
just move this here.
Good suggestion, thank you.
Yeah. I guess we'll just wait for these photos up here.
My understanding is you'll have 5 minutes, up to 5 minutes.
Oh, there's
So please
sideways.
identify yourself and then proceed when
Okay.
ready.
My name is Suzanne Meckel. I'm a resident of First Edition, and I have been since the 80s. I used to live on the 8th Street. I've been very involved in our neighborhood for many years and involved with trying to get the tree code back to what it used to be when we saved trees. Anyway, I'm the one who submitted actually a lot of those alternatives, and when they were being talked about by the planners, the garage that was towards the front, it was said that it was 22 feet in length, and actually it would be a standard size is 20 in length, and so I'm wondering if the 2 feet would make a difference in that, with the garage being, parked from front to back. So anyway, that was one of the alternatives. And I have these pictures. Well, let's see here. How do I move this? I'm not sure how I move these. Okay, back to where the plans were. Anyway, these pictures that she's showing here are pictures of garages that have a fir tree right next to them. Some are cements, and there's a recent one that was here's one from an older house with a double garage where they actually made the driveway around the tree so that they could access the garage door. And then also there's a recent, the earlier pictures were of a recent build where they used permeable pavers to preserve the tree so that it would get water to the roots. And I think that would be an alternative. This is the pavers with the fir tree right next to it. And then I also have a picture of a single-car garage that was done for tree preservation on a recent development as well. So, and then also I wanted to mention, I know recently the DRC heard there was an appeal for a development on 5th Street where there was variances given for a home to be built closer to the alley to preserve the existing structure. And I'm wondering why that cannot be done in this situation as well. And then there's another alternative. I was thinking the people are adding onto the house, and why couldn't we make the garage go into part of the house, and then they add on the other side that they're already adding onto, would be another alternative. But can you go to that picture of the, okay. Wait a second, it's not working. Okay, and I also have examples of many types of surfaces. There's a surface called a geocell that is something for tree preservation. It can go over the roots of trees. Can you show those? There's also water impermeable pavers. This is an alternative to having a solid surface driveway. There's also, they could have a gravel driveway. This system could be even used inside of a garage. And this would avoid excavation of the site and damaging the tree roots. And here I've put in a green square where the garage could go. As an alternative, that's 12 by 20. That's the existing garage, and it seems like a little bit, you could extend the garage into the house, and then where they've already are adding on, they could make up the difference on that side of the house, is another alternative. These are the permeable pavers. Here's an example of a single-car garage, and that's pretty close to the alley, so I don't see how the setback could be much different than that for this property that we're talking about. Those are just some examples I'm giving, and again, let's see here. For some reason, we're not working. Yeah, there we go. Again, here's that alternative. The setback on this seems like, I don't know why that's not, that seems to code to me. No? Okay. Is there variances, right? Anyway.
Excuse me, your time is about up. Did you have a conclusory sentence?
I just want to say that this tree is very significant. It seems like there's many alternatives that could be used in this situation to preserve something that's basically irreplaceable, and the loss of it is degrading the neighborhood.
Thank you for your testimony. Are there any questions of Ms. Meckel, commissioners? We appreciate you being here this evening. Are there other witnesses, either in person or by web-based video conferencing, to testify in opposition to the application? Anyone remotely or in person, neutral, neither for nor against the application, who wishes to testify? I did not, because I thought Mr. Housley was the attorney for the applicant and had spoken. But thank you for pointing that out. If no other members of the public wish to testify, we would open it for rebuttal testimony by the applicant.
I don't have too much to say other than the testimony we heard again tonight was a lot about trying to, what about this, what about that, what about this? In a sense, it was an attempt by the neighborhood to design by charrette here on the fly. Again, as staff had alluded to in their presentation, as well as our application materials, we conducted an alternatives analysis that meets the code criteria here to have the tree removal. given the location of the tree in that specific location and the fact that the critical root zone encompasses 24% of that lot there, especially on the western edge, where it would be feasible to do an expansion by right. They produced no evidence and no expert reports here to contradict those that were submitted by either Mr. March or Mr. Prager and confirmed by the city's contract arborist. We heard a lot of testimony regarding the community benefit and the aesthetics of the tree, but again, we would remind the DRC from our perspective, LO 55020803 does not meet the clear and objective criteria as mandated by ORS 187-3074, the needed housing statute that requires only clear and objective criteria be applied to houses. So with that, we'll conclude unless the commission's got any questions for either me or our expert witnesses.
Commissioners, are there questions of the rebuttal presentation? Commissioner Scherer?
So your opinion is that 55.02080803 on the what do I want to say, significant tree falls outside the bounds of the state law, is what you're saying?
That is correct, and I think we had that discussion earlier in June in front of this body, but again, we submitted our letter that provides that analysis.
Okay.
Any other questions?
I was just going to say, Evan, do you agree with that?
Well, it's my recommendation that the commission consider the application based upon the code criteria. If the commission finds that the code criteria are met, then I don't think we need to get into the issue about clear and objective statutory provision. If the commission finds that the code criteria are not met, then we would address those issues. This issue was formally raised in this proceeding this afternoon, and if that's the case, I wouldn't want to opine here from the bench, type of thing. I wouldn't want to address the statutory provisions without providing you a memorandum on it in greater detail. So my recommendation to the chair and the commission is consider the code criteria, determine whether or not you're going to approve or disapprove on that basis. If you end up disapproving on that basis, then we'll look at the clear and objective argument.
And provide staff an opportunity to evaluate the issue.
Well, yes, I don't think we have time. I don't have time to, I'd like to present that to you in a written form, okay? Because it's going to be, up to Peel, so.
No, I think it merits a thoughtful analysis if we get to that issue.
Yeah.
Mr. Housley, so we saw the Neighborhood Association presented slides tonight with what they characterized as other reasonable alternatives for development permitted within the zone to save the tree. And we saw the Neighborhood Association had an alternative number 1, an alternative number 2, and then something they labeled others, I remember it. And you were here and saw that. Is it the applicant's position that none of those under the code, as advised by you, are reasonable alternatives for development permitted in the zone?
That would be our position, and for a variety of reasons. Number one is either they would violate other provisions of the Lake Oswego Development Code as outlined by Ms. Cecile in her presentation. Number two is that you do have testimony in written format from both of our arborists that indicate, given the location of the tree, however we do any impact on that western side is going to impact the critical root zone and eventually impair the integrity of the tree, and it'll eventually come down. And they're able, again, if you have further questions for them on that, I'd be happy to provide them here this evening.
And Ms. Meckel had made some comment about a 2-foot difference in garage size that might save the tree. Is that something you heard and is infeasible?
Again, I heard that in sort of this what about line of reasoning, but again, given the location of the tree on the lot and where the critical root zone is, it's regardless of where the improvements are going to go, it's going to be within that root zone, it's going to be impacted.
And there was some comment made about a substance called geocell. Did you understand what that related to, or do you have a response to it? I think it was some type of surface that was being suggested.
I'm not familiar with that specific surface. I'm very familiar with the permeable pavers.
That was also suggested, yeah.
But permeable pavers are a way to infiltrate stormwater. It has nothing to do with protection of tree roots.
Thank you for responding to those questions. Vice Chair Smith?
So I heard your presentation before about the tree code, and then I read your materials for this application. Is it that you're saying that if we apply the tree code to your application, it meets the code, but if we disagree with that analysis, we can't apply the tree code because of these cases that you've cited? I guess I'm a little confused. It's like you use the code in one situation and then you say it's not valid, the tree code that we say that we comply with. I got a little confused on what the analysis was.
No, and I appreciate that, and part of that has to do with issue preservation in case this case winds up in front of the Land Use Board of Appeals. But from our response here is we believe we've met the city's code criteria here as evidenced by the staff report and recommendation of approval, as well as the evidence before the DRC here. I've heard nothing from the testimony either from the appeal or tonight that contradicts any of that best evidence. But if the DRC were to disregard the staff's position on this matter and grant the appeal, we would just remind the DRC that from our perspective, we do not think that the City of Lake Oswego code meets the clear and objective requirement under the needed housing statute. And therefore would be subject to appeal and potentially attorney's fees in front of the Land Use Board of Appeals.
So, Evan, if we, based on our decision, then theoretically would be appealed to the City Council and then theoretically to LUBA. So I don't expect you to analyze his arguments, but is it issue preservation for LUBA part of these, what he's putting forth in the paperwork? Is that?
Yes.
Okay.
Yes. And, well, issue preservation and an alternative. I mean, if we meet the code, if the applicant meets the code, then we don't need to go any further. If you find the applicant hasn't met the code, then his alternative argument is I don't have to meet the code because it's not enforceable due to the statutes. And in any event, should you find that he's met the code, okay, under the criteria, and if it was appealed and if the council felt otherwise, he still has preserved his issue to the council and to any appellate bodies from there to argue that the code is not enforceable. So.
Okay, because what I heard as part of Mr. Housley's presentation is there was what I understood was that, it's like this issue, his firm keeps bringing up this issue and then suggesting to the city that they fix our tree code. And so there are a couple of lawyers on the DRC, so we understand, we think we understand why this argument keeps coming up, but it also is confusing that we have applications that keep coming up saying our tree code is invalid. Your tree code is not valid. We're going to go to LUBA and tell you once again your tree code is invalid. So I'm wondering if at some point city attorney or does an analysis so we at least have something to I guess respond as opposed to somebody keeps telling us that our tree code's not valid, I guess.
Well, this is the second case in which that's been argued for us. And the issue was before the council on a previous appeal, and the council did not need to address it, and it did not. Until I get, until there's no other way,
That's all you need to see. Now I understand
so
what happened. I apologize. So I didn't realize that was so. Okay, thank you.
Thank you, Vice Chair Smith. So, Mr. Housley, I understand it's acceptable to the applicant that the DRC initially evaluate the application under the code, and then only if the application is not sufficient under the code that we would reach your clear and objective argument, which you've raised as an alternative basis.
Yes, that's correct. And again, just remind the DRC, we are okay with the staff recommendation and staff recommended conditions.
Thank you. Any other questions?
Thank you.
Thank you very much. Are we at a point, City Attorney, where we can close the hearing, or do we have other inquiries to make?
No, you can close the testimony portion of it if you have any questions for staff, and then proceed to deliberation.
Well, very good. As the applicant has presented the application and we've had testimony and rebuttal, we will now close the public hearing aspect, public testimony aspect of today's hearing on this application. Are there questions of staff before we go into deliberations? I did have a question. Commissioner Scherer, go ahead.
Would you walk me through the significant tree analysis 3B 55.02.080-3 3B? Walk me through that one more time.
Last slide of my presentation has the. So you're asking about the alternatives to tree removal have been considered and no reasonable alternative exists? That's what you're.
I'm asking that we're determining it's a significant tree
Yes.
and go from there.
Yes, so it's significant due to size.
Yes?
Yes. And so the alternatives need to be addressed by the applicant. And they need to show that there's no reasonable alternative to the removal of the tree. That analysis was, yeah, that allows the property to still be used as permitted in the zone. That analysis was the drawing that they submitted that showed the double-car garage or two-car garage with alley access meeting the setbacks, the current setbacks that it needs to meet. And they were showing that it was still affecting the northern roots system, and that the excavation for that would have to be at least 2 feet deep, and it was coming within 1 foot from the trunk of the tree. So it wasn't a reasonable alternative because it's not protecting the tree in any sense.
Does that answer your question? Any other questions of staff? I did have a question, perhaps of Attorney Boone or Director Namanalu, as well as Planner Sissel.
Well, I'll answer.
There was a comment made by the neighborhood association that we should grant a variance to some of the requirements for development that are precluding construction that would save the tree. Could you comment on that as a legal matter? Is permitting a variance something we can require relating to development permitted in the zone?
No. That has been ruled on by the commission, by the commission and by the council. A variance is a discretionary path. An applicant can ask for it, but there's no ability in the tree code, which is, as stated in the staff report, is the tree code is, if you will, subservient to the development code. The question is, do the alternatives considered no reasonable alternative exist to allow the property to be used as permitted in the zone? So we're looking to what is a person permitted to do in the zone without having to go through any discretionary, maybe I'll get it, maybe I won't type of basis. There's no, this body is sitting as a tree code appeal body, not as a body that will determine whether there's evidence warrants granting a variance. That's a different application, different criteria. That's not before you. The code also goes on to say, in the tree code, it also says, so long as the alternatives continue to comply with other provisions of the Lake Oswego Code. So the other alternatives must comply with the code. And again, there's nothing in there that says that the DRC can, as a tree appeal body, and the history used to be that the tree appeals were heard by the Community Forestry Commission. There was a separate body.
I see.
That heard that. Okay. They were heard by the, they met so infrequently, strangely enough, okay, that eventually the code was revised to say that since the DRC does quasi-judicial hearings, and this is a quasi-judicial matter, that the DRC shall do it. But it is sitting as a tree review body, not as a land use body at this point, okay? It's two separate things. So there is no authority for you to sort of reach out and we've noticed whether or not a tree should be removed. We haven't noticed that a variance might be granted. I mean, you know, somebody might, it's a whole different set of people out there who might worry about variances. So, as cited in the staff report, and I'm going to go up to the, I think, top. Cited in the staff report on page 12, a section called Prior Interpretations by DRC and Council. The Commission and Council had previously interpreted this exception and found that reduction of size of development is permitted in zone is not required, or variance is sought to show that reasonable alternatives have been considered, and there's a string of cases. The Commission finds it's not a reasonable alternative to require the applicant to reduce density, construct a different type of dwelling, or seek a variance. And that is out of your case this year, I think about 3 months ago.
Yes, I saw that. Well, I appreciate that clarification. I just wanted to address that point that had been brought up in the hearing. And I just had one other question. So I noticed staff, as a condition of approval, if I'm saying it correctly, had asked that one Douglas fir be planted as a mitigation tree and that a native tree of the applicant's choice be planted. I just was curious about that thought process, why the condition was not to plant 2 Douglas fir mitigation trees. If you have a comment on it, maybe that's such a minute point that.
So my recollection is that we didn't have a specific species that we required for this application. It was 2 native species. It's a 2-to-1 ratio for when a tree is significant for development reasons, that they have to plant 2-to-1 removal. I don't recall them specifying that they would plant a Doug fir, that we would be requiring that. It would just be 2 native trees.
Okay, I thought I had read that somewhere. So there was no analysis by staff recommending a mitigation trees be a Douglas fir tree?
No. And on that, the commission does have conditioning authority under 5502.094 if certain criteria are met, which the applicant has argued is not clear and objective. And if that's the issue, I would agree. That's it, because you have to you balance and look at the neighborhood character and that sort of thing. So they would object to requiring any mitigation above and beyond the clear and objective standards on that. And staff did not recommend anything in this case.
I see. I was looking at the initial summary of staff findings that did refer to a Douglas fir being required for one of the trees. But perhaps that's superseded by the appeal. Any other comments or questions of staff before we go into deliberations? Do commissioners have thoughts they would like to share about this? Commissioner Dews? I'll put you on the spot.
Well, I just want to say that I appreciate the people that came tonight and took the time out to speak. I mean, the passion and the concern for your neighborhood is heard very well by me. I really appreciate that. I think that's what helps to make Lake Oswego such a wonderful place to live, to have residents as concerned as all of you. However, given the what seems to me is a pretty clear case of that the applicant does have the right under the zoning to make this change or this addition. And I feel that given that there really isn't much of a decision, that we have to live with the code.
Thank you for those comments. Any other commissioners? Commissioner Poinsett, did you have any thoughts you wanted to share on this?
Not on this.
Commissioner Scherer? Nope. Vice Chair Smith? No. Well, clearly this is, I think the evidence shows this is a significant tree because of its size and its prominence in the neighborhood skyline. But my understanding is that we cannot require the applicant to apply for a discretionary variance, and that the evidence in my mind shows that no reasonable alternative that would allow saving the tree exists that's allowed or permitted for development in the zone. So I'll be approving the application. Any other thoughts? Is there a motion? I would move for approval of AP 22-06, the application itself, declining the appeal, subject to the conditions of approval recommended by staff, asking staff to return draft findings at an appropriate time in the future.
I second.
Any further discussion? Please call the roll.
Arthur?
Yes.
Smith?
Yes.
Shear?
Yes.
Poinsett?
Yes.
Hughes?
Yes.
5-0.
All right, this is a tentative decision, and written findings to be brought back to the commission at its next meeting on December 5, and there is nothing scheduled.
Yeah, there is no other item to scheduled on December 5th, so if the commission would like, we can meet remotely via Zoom at an earlier time, as we've done in the past, if that is okay with you.
Is that acceptable to the commission? Is there a meeting on December 21st?
No, not at this point. We don't have anything scheduled.
Could be, we've had our biggest cases.
So that would be 6 p.m. then on December 5th?
Yes. And Director Namanaloo, we did have some discussion in the past about our letter relating to the Aquatic Center. I wondered if there was some recommended approach to presenting it to the City Council.
Yeah, so I did follow up on that again, just to check to see if there is progress. Our engineering department is collaborating with the Parks Department right now on that. They are trying to come up with an estimated cost, and also there's some, they need to figure out the width of the right of way and all those things. So that's going to take a little bit of time. So I don't have a specific timeline for you other than they are looking into this. The city manager is aware of that. Once we have that information, then they can present that to the council. But they don't want to just bring it to the council without having, a cost estimate and the logistics of it so that they understand what the issues are.
Yeah, that's an important bit of information. On a different topic, do you know, is there a boards and commission summit scheduled at this point?
There
in the
is.
upcoming future?
It is scheduled for early January. They
Okay.
have not sent out the official invitation yet, and when it does come out, I will be forwarding it to both you and Vice Chair Smith, although I think all of the DRC members are welcome to attend. The DRC at the Boards and Commission Summit does not, they're not a goal-setting body, so there won't be any report by the commission, but the commission is always attended. I think it's good for the commission to see what other boards or commissions are doing, and, it's just a really nice event, and we hope that you'll be able to attend.
Well, I think I've shared with you in the past my view that it would be perhaps interesting if we did do a little summary of our activity over the course of the year. Granted, we're not setting specific goals, but we might comment on the number of hearings we've had, the types of hearings,
Sure,
the
we could do that.
appeals, if any, what the results have been. Any other business for tonight? Commissioner Scheer.
So are we ever going to address this tree code issue so we can, I can tell by the look on your face that is.
Well, it is the goal of the council right now. Their goal is to update the urban community forestry plan, and that is currently underway. They've started with the State of the Urban Forestry Report, which the council, I believe, is scheduled to hear in December. And then that will provide, kind of baseline data of where we are with, well, it'll actually update the report from 2009 of the current state of trees in the city. Once we have that information, then we can move on to update the urban and community forestry plan, and that will provide some policy recommendations on updating the tree code and other city policies related to trees. So it is underway, but it is going to take some time unless the council directs us to address this clear and objective issue earlier. We have not been directed to do so yet.
Okay. And the Forestry Commission, can they hear these?
I don't think it exists any longer. I think we are that, in effect.
And Chair Arthur, I do have one more update for you, if you like, if I
Please.
can. The commission did hear an appeal of a staff decision a few months ago regarding an addition to a home on 5th Street, 520 5th Street. And this is for a number of variances in an R2 zone.
Yes.
And the council, it did get appealed to the council, and the council did hear that appeal. They upheld the DRC decision to approve that, those variances. And so I just wanted to give you an update on that, since that was an application that was before the commission.
No, I do appreciate that when you report back to us subsequent activity on matters we've considered. Any other business tonight? Hearing none, our meeting is adjourned. Thank you.